We now move to Virginia. The floor is yours.
Thank you, Hani. Thank you, Hila, and everyone at TrafLab for inviting me and hosting me today. It's great to see everyone and to hear all these very stimulating discussions. I'm delighted to speak today, and I'm also particularly a bit like Gianni, I think, because I know Hila, I know Hila a few years now, and I heard her present the draft article at the time, A Labor Approach to Human Trafficking, I think, at the Hebrew University at the conference a few years ago. So I was there and we were having this great discussion that started there and has inspired a lot of what I've done after that. It's great to see how this has become a major project. Amazing that Hila has developed this fantastic team of researchers. And it's also great to see Mayan be part of this, whom I've known a few years now too. So it's very exciting to be part of this, yes, and to participate in today's panel. I found the report admirable. I liked a lot what you're doing. And for me, it's great to see labor law scholars working in the field of human trafficking. One of the points that I really liked was the fact that when you talk there were a lot of things I liked, but one of these was the fact that when you talk about prevention, you do not refer to what people often working in human trafficking identify as prevention. And I really liked that because it was always obvious in my mind that this is what it should be about. But in your report, I saw how prevention of human trafficking involves protection of labor law and labor rights. The report also resonates a lot with the work that I've been doing in recent years, in the last couple of years particularly, and he asked me to talk about this and try to connect this to the report. And so I'll talk a bit about that. So I'm finishing, I'm sending it to the publishers next week, I think, this book that's called Structural Injustice and Workers' Rights. And in that book, I do something similar, let's say, to this report, in the sense that I look at, similar in a way, but different in another way. I look at structural factors that create vulnerability to exploitation. In that respect, I focus particularly on the role of the law. One example is what Mayan discusses in a recent article that she published in the Journal of Law and Society, and the report also discusses restrictive visa schemes and how these visa schemes create vulnerability to exploitation of workers. And I'll say a little bit more about that in a minute. But it is different to the report, and this is linked to a critical comment, I guess, that Joel made earlier. It is different in the sense that I have decided not to focus on the most extreme forms of labor exploitation. This report and the work and Hila's work and TrafLab's work more generally criticize the law of human trafficking and policy responses to human trafficking and all the political developments around human trafficking across the world in many countries. It's very fashionable. Human trafficking, modern slavery is very much part of the UK government agenda. They are very critical of modern slavery, very much against it. They have criminalized. We have new criminal laws on modern slavery in the UK since 2015. At the same time, there are all these other forms of labor exploitation that are there in the report, but they are not the primary focus. I mean, in the end, it could be said, as Joel said earlier, that is this really about human trafficking, or is it about a much more broader account of labor exploitation? Which it is, and I don't mind this at all. I'm very much in favor of it. But yes, scholars focusing only on human trafficking, I understand where they're coming from when they raise this. In relation to in this work that I do in this book that I am finishing, I talk about concrete, identifiable legal rules that create vulnerability to exploitation. And in that respect, I focus on, I have 4 examples in the book, 4 chapters that are these examples. First of all, one that is examined very nicely in the report. And I want to ask Mayan and Hila something in a minute to clarify something for me. So first of all, migrant workers and how there are both restrictive visa schemes, but also legal rules on undocumented workers that make all these workers very vulnerable to exploitation and systematically exploited. They are systematically exploited by employers to whom they are bound through restrictive visas, etc., or undocumented workers who in the UK, just to bring a couple of examples that Hila wanted me to mention. In the UK, we have a visa for domestic workers that effectively ties these workers to the employer with whom they arrived in the country. They can change employers in very limited circumstances. And it's really, some recent changes are ineffective. So basically, in effect, domestic workers in the UK are bound to the employer with whom they arrive. At the same time, undocumented workers in the UK, under the Immigration Act of 2016, it's a crime for someone to work as an undocumented worker, but also any wages that they earn can be confiscated as proceeds of crime. So the wages of the workers, they have done the work, if they get any wages, they can be confiscated by the authorities because it was the result of a criminal offense that they committed working illegally. So in the area of migrant workers, we see that very much, and some countries I am sure more than in others, and the UK is one of the best examples of exploitation, I guess, through law, where migrant workers are made through identifiable legal rules vulnerable to exploitation. The report refers to the visa, to the tied visa in Israel and the Supreme Court decision of 2006, I think. But then you explain how there remain visas that effectively bind the workers. And I would like afterwards in the discussion, if there is an opportunity to understand a little bit more how there are visas that remain like that despite the decision of the 2006 decision of the Supreme Court of Israel. Another issue that I discuss in this book that I'm finishing is our category of workers that I call captive workers. People working in prison, working prisoners, those who do unpaid work as a sentence, and those working in immigration detention as three other categories of people who are forced to work, and they are excluded from labor law protections through law. The legal rules exclude them from minimum wage and other labor law protections. Another example, as I have said, in this book, I have decided to not only focus on the most extreme forms of labor exploitation. So I also look at welfare conditionality schemes and how schemes that make welfare benefits conditional upon seeking work and accepting work, how they push people and force people into exploitative work. And when I use the term exploitation, I don't use it in the sense that that it is usually used in the human trafficking discussion, which is about the worst forms of labor exploitation. So welfare to work schemes, particularly those that are very punitive and that impose very harsh sanctions, force people into exploitative work, into very bad work, precarious work. And then I also talk about precarious work more generally, and how people who work through agency or people who are in 0-hour contractual arrangements, people who are in flexible work that is supposed to be valuable and all that, according to the UK government and other governments, how they end up, how there are legal rules that make these workers as well very vulnerable to exploitation. So the idea there is that there are all these structures of exploitation that are where the law has a major role to play in creating vulnerability. Immigration rules, people working in prison, immigration detention, and doing unpaid work as a sentence, offenders doing unpaid work. People who are forced to work through the social security system, through the welfare state, and people who are into other precarious work in certain extreme situations. And the argument is that it is not just the visas that create vulnerability to exploitation that is systematically exploited, but that we identify patterns where legal rules create vulnerability to exploitation that is exploited systematically in several areas, and that these are increasing, and there are these patterns that are increasing and are becoming more routine, and we get used to them because they're everywhere. In the UK, there were labor shortages, there still are labor shortages in the UK and elsewhere. But in summer, there was this discussion that the government, one of the ministers said, let's use prisoners. We have a free working hands in prison. Why should we worry about labor shortages? So, these are becoming more normalized, let's say. The other thing is that, and this is related to the keynote that we heard earlier, and is about the role of human rights law. And these are the final 2 chapters of this book I'm finishing, about how human rights law can be used here. And when I talk about human rights law, I have in mind something much more like the special rapporteur spoke to us earlier about. So it's not, in the past, when people thought about labor exploitation and human rights law, very often they thought what came to their mind was forced labor, human trafficking, slavery, servitude. But because of my training, I don't know, just because how I'm thinking, this is not how I think of human rights law. So in this book, and in this talk today, I wanted to think, I'm trying to think more about how human rights laws and rights, not just the prohibition of forced labor, the prohibition of human trafficking, but other human rights provisions. For example, the right to private life, the prohibition of discrimination, and social rights, rights to fair wages, etc., can be used to challenge some of these legal rules that create vulnerability to exploitation. Human rights courts, other bodies, other institutions like including the special rapporteur, they look at state action and how, whether the states, the way they act in compliance or act in compliance with human rights law. So I think that if we identify legal rules that violate human rights law, and we identified human rights provisions, case law, reports, etc., that can capture this kind of exploitation, we can challenge these unjust structures that we are talking about. So 2 things then to conclude, because I also really look forward to the discussion. First, I think I didn't say one other thing that I really liked in the report, which is the policy recommendations, the fact that the report makes concrete policy recommendations. It's not something that we normally do, that we often do in academic work. When we write an article, we don't often write detailed policy recommendations, but I think that it's incredibly valuable that a report like that by very thoughtful academic scholars contains policy recommendations for change. So on the one hand, then, what I want to understand is, to what extent then should we be focusing only, even though I appreciate that this is what this project is about, to extreme exploitation. And I think this is also linked to the special rapporteur's concern in the beginning, which was a concern both about academic work focusing on this, but also the role of the special rapporteur on modern slavery, on human trafficking, etc., who are also, this is the mandate, this is the scope of the work, just to just focus on extreme exploitation. But also on the other hand, something separate, which is my own, project, research agenda, Hila knows, many years now, to consider the role of human rights law in challenging some of these aspects of labor exploitation, and not only the most extreme ones, but also others. Thank you, and I look forward to the discussion.
Hani, you're on mute.
Oh, apologies. I was thanking you, Virginia, and saying that thank you for the stimulating talk, and that we all look forward to reading your book when it is out. And last but not least,